Friends, today I would like to bring to your kind notice about the details of a new controversy that has rocked our nation, India. As you know very well, a routine gazette notification from the University Grants Commission rarely makes headlines. But this time, a notification containing a set of new rules has triggered a nationwide debate, drawing sharp reactions from students, parents, political leaders, and even the Supreme Court of India. At the center of the storm are the University Grants Commission's 2026 Equity Regulations, notified on January 13. These new rules, meant for strengthening protection against discrimination in higher educational institutions, have gained a dose of controversy. Instead of bringing clarity and consensus, they have sparked confusion among all sections of society. The regulations were framed following a directive from the Supreme Court in September 2025. The court had asked the UGC to strengthen its 2012 anti-discrimination framework while hearing a public interest petition filed by Radhika Vemula and Aveda Salim Tadvi, the mothers of Rohit Vemula and Payal Tadvi. Both the students, Rohit Vemula and Payal Tadvi, had died by suicide, allegedly after facing caste-based discrimination in their campuses. The petitioners, mothers of the two students, argued that existing safeguards were too weak and demanded a robust system with real accountability. In June, with a direction given by the Supreme Court, the UGC introduced sweeping changes. Under the 2026 regulations, all higher educational institutions must establish equal opportunity centers. These centers will be overseen by equity committees, which must include representation from scheduled castes, scheduled tribes, and other backward classes, along with faculty members, students, and civil society representatives. The new framework also introduces strict timelines. Complaints must be reviewed within 24 hours. A report must be prepared within 15 days. This means all institutional heads have just 7 days to act. Institutions that fail to comply with this rule could even be barred from offering degree programs. Additionally, universities are also required to set up 24-hour helplines, create equity squads to monitor vulnerable areas on campuses, and appoint equity ambassadors in all departments, hostels, and libraries to report violations. Supporters of this new mechanism say these measures finally give teeth to anti-discrimination laws, but critics argue the language of the regulation is vague and potentially exclusionary. One major point of contention is the removal of a clause from the draft version that would have penalized false complaints. The final notification does not include any such provision, raising fears that the mechanism could be misused. Another great concern is the separate definition of caste-based discrimination, which specifically mentions SC, ST, and OBC communities. Critics argue this creates the impression that only these groups can be victims under the regulation, leaving out students from the general category who may also face discrimination. Some have even described this as opening the door to reverse discrimination. The Supreme Court, while staying the implementation of the 2026 rules until March 19, observed that the drafting could create confusion and unrest among students. The court also questioned why ragging, a widespread form of harassment, was not explicitly covered under the new framework. For the present, the older 2012 regulations remain in force. Unlike the 2026 version, the 2012 rules define discrimination more broadly but lack strict enforcement timelines. As the matter returns to the Supreme Court of India, the larger question remains: how can India build a campus environment that strongly protects the marginalized while ensuring fairness and due process for all? The answer may shape the future of equity and inclusion in Indian higher education.